Hey everybody, this is Damon Moore. I'm your presenter, and I'm excited to bring you this presentation about Texas family law. I own the law office of Damon Moore. My team has an office in Austin, Texas, and we handle family law matters throughout the state. You can obtain more information about me and my firm by checking out my website. The website address is www.damonmoore.com. I'll share a little bit of information about myself so that you can understand who I am. This way, you'll have a better feel for the person who's delivering this information to you in this webinar. I've been representing clients in family law and domestic relations matters since 2005. I represent or have represented hundreds of people in divorces, child custody disputes, termination of parental rights, and adoptions. I was also a mediator and the chairman of the board of directors for the Austin Dispute Resolution Center, which is believed to be the city's largest not-for-profit alternative dispute resolution organization. I want you to know that you're in good hands as we venture into this webinar. We're going to cover 4 topics in this webinar: divorce, conservatorship, child support, and property division. And at the end of the webinar, I'm going to give you a free gift that's sure to help you as you work through this challenging period of your life. If you have any questions, then you're welcome to reach out to me. Let's get started. In Texas, there are several reasons you can claim you want a divorce: insupportability, cruelty, abandonment, conviction of a felony, living apart, or confinement to a mental hospital. The first condition on that list is insupportability. That's the most common. Insupportability is what we commonly call a no-fault ground for divorce. This is what the Texas Family Code says. On the petition of either party to a marriage, the court may grant a divorce without regard to fault if the marriage has become insupportable because of discord or conflict of personalities that destroys the legitimate ends of the marital relationship and prevents any reasonable expectation of reconciliation. A more simplistic way of saying it is that one of you just does not want to be married any longer. Now, this is the easiest way to get a divorce because you only have to prove that one of you no longer wants to get married. The other methods I will discuss require you to prove something about the other spouse. The other methods require you to prove that the other spouse was at fault. Now, you may be wondering why someone would want to obtain a divorce for a fault-based reason if he or she could get a divorce more easily with a no-fault reason like insupportability. Well, sometimes a person will use a fault-based reason to obtain a larger share of the property division. We will talk about property division a little later in the webinar. For now, let's take a look at the other fault-based methods for getting a divorce. Let's start with cruelty. The court may grant a divorce in favor of one spouse if the other spouse is guilty of cruel treatment toward the complaining spouse. Now, the court may grant a divorce in favor of one spouse if the other spouse has committed adultery. The court may grant a divorce in favor of one spouse if during the marriage to the other spouse has been convicted of a felony, has been imprisoned for at least a year in the Texas Department of Criminal Justice, a federal penitentiary, or the penitentiary of another state, and has not been pardoned. The court may not grant a divorce under that section of the Family Code against a spouse who was convicted on the testimony of the other spouse. The court may grant a divorce in favor of one spouse if the other spouse left the complaining spouse with the intention of abandonment and then remained away for at least 1 year. And finally, The court may grant a divorce in favor of one spouse if at the time the suit was filed, the other spouse has been confined in a state mental hospital or private mental hospital in Texas or another state for at least 3 years, and it appears that the hospitalized spouse's mental disorder is of such a degree and nature that adjustment is unlikely, or that if adjustment occurs, a relapse is probable. So that's a lot for the confinement in a mental hospital. If you're dealing with a situation like that, then you should reach out to an attorney and kind of discuss that one a little bit further. It might give you a better feel for whether confinement in a mental hospital is the right grounds for you. And again, there's a split here that I've kind of illustrated in this slide or this image of no fault versus default versus fault. As you can see, there's one way to get no fault, and there are multiple ways to get a fault-based ground for divorce. Let's talk about conservatorship. Conservatorship is the term used in Texas to address legal and physical aspects of sharing children and managing the children's affairs. One of the things you want to keep in mind in Texas courts, it's conservatorship. It's not custody. The legal and physical aspects of sharing the children include the following: schooling and education, medical, dental and surgical care, psychological and psychiatric care, religious upbringing, moral principles, and socialization and behavior, and financial welfare, and legal rights and representation, and employment, and involvement in the arts, and consent to marriage, and consent to armed forces enlistments. It also involves the right to determine where the child resides, the right to collect child support, the right to have access to the child, and the right to inherit and bequeath assets to the child. While it's on my mind, I'll say that in the streets you hear the term visitation used a lot, but in Texas courts, it's typically going to be called possession and access. Now, when we talk about conservatorship, it's important to recognize that there are two categories of conservators. You have managing conservators and you have possessory conservators. If you are a managing conservator, then you might share that role with the other parent. If that is the case, then you're going to be called a joint managing conservator. If you are the managing conservator who is not sharing that role with the other parent, then you are a sole managing conservator, and the other parent is a possessory conservator, if he or she has rights at all. Earlier, I mentioned a list of legal and physical aspects of sharing the children and managing their affairs. In the Texas Family Code, those things are often called rights and duties. And it is important for you to know that those rights are not always shared equally. For example, in some cases, the parents might share the rights to make decisions about the child's schooling, but not share the rights to consent to medical procedures. You can be a joint managing conservator without having equal decision-making power. It is also important to know that some rights are not shared. The right to designate the child's residence and the right to collect child support are two rights that are not shared. Let's talk about the right to designate the child's residence. In a case that has children, the court will usually designate one of the parties as the one who determines where the child resides. The court may require that the child reside in a particular school district. That would be a very narrow geographic restriction. But the court could decide that the child is limited to a particular city or a particular county or county and surrounding counties, a particular state, a particular country, or there might not be any restriction. In my experience, this is one of the most heavily litigated aspects of the case. When thinking about the parent's exclusive right to collect child support, there are a number of things to take into consideration. Judges tend to determine child support by looking at something we call the Texas Child Support Guidelines. You start with the gross amount of money that's earned per month, and then you subtract certain deductions. You take the number that results, and then you multiply that number by a number that's based on the number of children that the parties have together. This presents a kind of an example of what you might see. From the first line, you see it starts with the gross money earned per month, and you're looking at the wages, the commissions, the self-employment income, any rental income or other income. Then you're looking at the actual deductions for income tax and Social Security and health insurance and union dues and other things. And then you're going to get a total of the actual deductions. You subtract that from the gross income, and then you'll end up with a net money received, and you might multiply that by a number. So I said by the number of children, but that doesn't mean that if you've got one child, you multiply that number by 1. It might mean that if you've got one child, then you multiply that number by 0.2 or some other number that comes from the guidelines. Now, it's important to note that there are circumstances in which the court will depart from the child support guidelines, but you are going to have to give the court a reason to depart from the guidelines if that's what you want. To say it differently, if you want the court to give you more child support or require you to pay less in child support, then you need to argue that something in this list of considerations is important enough to order more or less in support. The age and the needs of the child, the ability of the parents to contribute to the support of the child, or any financial resources available for the support of the child, or the amount of time or possession and access to the child, or the amount of the obligee's net resources, or any kind of managing conservator actual or physical custody of another child, or alimony or spousal maintenance, or expenses for education beyond secondary school, or benefits furnished by an employer or another person or a business entity. The court might also consider several other things, and I'll draw special attention to the things that are in red type here. The special or extraordinary educational or healthcare or other expenses, or the cost of travel to exercise possession, or the cash flow from any real or personal property. And you'll see in number 17, they say any other reason. That's any other reason that's consistent with the best interest of the child, taking into account the circumstances of the parents. So they provide a list of things, but they also make some room to keep things kind of broad or they don't want to miss any opportunity to consider something that should make a difference. Let's talk about how the court determines conservatorship. The court determines conservatorship by considering a set of factors to determine what is in the best interest of the child. A non-exhaustive list of those factors includes the following: the desires of the child, the physical and emotional needs of the child now and in the future, the emotional and physical danger to the child now and in the future, the parental abilities of the individuals who are seeking custody, programs that are available to assist these individuals to promote the best interests of the child, the plans for the child by these individuals or by the agencies that are seeking custody, the stability of the home or proposed placement, the acts or omissions of the parent which may indicate the existing parent-child relationship is not a proper one, any excuse for the acts or omissions of the parent. Now here's something important to note. The factors that I've just listed are not exhaustive. Some of those factors may not be appropriate in a particular case. Other factors that I did not list may be more important. Also, undisputed evidence of one factor may be sufficient. You should also note that a parent's inability to provide adequate care for the child, the lack of parenting skills, poor judgment, and repeated instances of moral conduct may also be considered when looking at the child's best interests. If you want more information about issues that are related to conservatorship, then feel free to reach out to my office. Let's talk about property division. When you get divorced, the court is going to divide your property unless you and the other party reach an agreement about how the property should be divided. The court thinks of each piece of property you possess as fitting into one of three marital estates. You have property that is owned by the spouses together and referred to as community marital estate. You have separate property owned individually by the husband and referred to as the separate as the husband's separate marital estate, or you have separate property owned individually by the wife and referred to as the wife's separate marital estate. Any property that is deemed to be community property is divided between the parties in whatever way the court thinks is just and right. Any property that is deemed to be one party's separate property is awarded to that person without any division. So, for example, imagine you have a married couple with a husband and wife. The husband received a car from his parents before he married his wife, and the couple purchased a house after they were married. If they divorce, then it is likely that the court will give the car to the husband, then divide the house between the husband and wife in some way. So at this point, you may have realized that it's important to know what makes something separate property and what makes something community property. A spouse's separate property consists of the property owned or claimed by the spouse before the marriage, the property acquired by the spouse during marriage by gift, devise, or descent, and the recovery for personal injury sustained by the spouse during marriage, except any recovery for the loss of earning capacity during the marriage. Community property consists of the property other than separate property acquired by either spouse during the marriage. So you look at it, if it's not separate property of one party or the other, then the court's going to presume that it is community property. Now, when you go to court and you are dealing with a property division issue, there are going to be some presumptions. One of the presumptions is a presumption of community property. Property possessed by either spouse during or on dissolution of marriage is presumed to be community property. The degree of proof that's necessary to establish that property is separate property is clear and convincing evidence. So if you believe the property is your separate property, then you've got to prove that to the court, and you've got to prove it by a standard that is higher than what they call preponderance of the evidence. And if you want to discuss that issue any further, then please feel free to reach out to my office, and I'm happy to talk about that with you. Another concept that is important to understand is called the Inception of Title. And that's the idea that the character of the property is determined at the time the right to own or claim the property arises. There are a couple of concepts that I can't dive into too deeply in this webinar because it would make the webinar much longer than it should be. However, I want to tell you about the concepts so you know that they exist. One concept applies to property that is purchased with money from a separate estate. The reduction of the principal amount of part of a debt under certain circumstances, the refinancing of the principal amount that's described in one of the other sections, to the extent that there's some refinancing involved and that reduced the principal amount in a manner that's described in one of the other subdivisions, or capital improvements to property, or a reduction by the community property estate of an unsecured debt that's incurred by the separate estate of one of the spouses. This reimbursement section of the code really provides some opportunities, and you want to make sure you're on top of it. As I'm talking about it here, I'm not able to dive in as deeply as I'd like. However, I think it's really important that you're aware that this opportunity for reimbursement exists. So if you go through and you determine that you've had this, you've used some money that you think was part of your separate estate, or you've used some money and it's gone to the other person's separate estate, and you don't think that your interests are being adequately represented, then you still have an opportunity to address that situation with the court. Now, the burden of proof for the party that's seeking to offset the claim lies with the person who's trying to offset the claim. So if you're saying that you're entitled to some kind of reimbursement, well, then you're going to have to prove that to the court. We've talked a little bit about the the community assets, but I think it's also important that we keep in mind that community debts are addressed in a divorce as well. If you or your spouse accumulated debts during the marriage, those debts are called community debts, and those debts need to be valued and divided. I think it's also important to remember that you've got sometimes you have issues that involve third parties. And sometimes people run into problems in these situations because you've got a third party, let's say such as a bank, and both people took out or signed on for a mortgage on the property, and now there's a divorce, and there's some question because the husband or the wife has an obligation to pay, and a court-ordered obligation to pay, and the bank is still going after the person who wasn't obligated to pay by the court. It's important to recognize in those situations that the court order or the agreement between the spouse as to who pays what, that has no bearing on the third parties. Now, a lot of people try to address this issue by having the spouse who takes the house refinance the mortgage, but sometimes that does not work. But this is something that you definitely want to address and be aware of, because it can get you in trouble at some point down the line, especially with something like a house where it may take many years for you to pay it off. Another topic I want to address in this webinar concerns pensions and retirement plans. In particular, you want to be aware of any employment benefits, Social Security, or military or federal pensions. If you have to value a pension or a retirement plan, and that is a tax-deferred savings account, then you would look to the value in the summary statement. To find the community share, you would take the number of years that the employee spouse was part of the plan, and then divide it by the total number of years of employment when the marriage was dissolved. You can value it yourself. You could use an accountant or a lawyer, but you should use a professional actuary to value the plan and the community interest. There are a few ways to deal with a pension. You could deal with it through a waiver, through a trade-off, or through a payoff, but a description of each of those things is beyond the scope of this webinar. You should call the office if you want to discuss those things in greater detail. We'd be happy to talk to you about that. But one thing I want to make sure that I discuss with you is the QDRO. A QDRO is a domestic relations order that creates or recognizes the existence of an alternate payee's right to receive, or assigns to an alternate payee the right to receive all or a portion of the benefits payable with respect to a particular or a participant under a retirement plan. And that includes certain information and meets certain other requirements. In other words, if one spouse works at a job and earned retirement benefits, but that spouse wants or has to give that money to another person, then a QDRO is going to be completed to direct the employer to give the benefits to another person. There's some other issues that you'll see that will come up in situations like this when you're dealing with divorces, transferring titles to property if you're dealing with real estate, vehicles, bank accounts, tax refunds, or insurance policies. Those are all also issues that we get into in more detail if we're having a consultation with you. But for the purpose of this particular webinar, I just want to point out that those are things that you should certainly be aware of. So let's talk about pricing. I suspect that there are a number of you who plan to represent yourselves, but you don't have to do it alone. We want to help you do that. So we've created a do-it-yourself device that will help you do that. If you sign up for our do-it-yourself service, then you'll be able to access the basic forms, papers and videos that give you the information you need to represent yourself in court. And if we do not have a form or a lesson that you need, then we will create the form for you at no additional charge. That service is currently $197 per month. And if it's something of interest to you, then you certainly want to reach out to us and ask for that information. Now, you may want to use my firm to do mediations for you. A mediation is a method of resolving your case by using a neutral third party who will meet with both parties and help the two parties come to an agreement that works for both parties. If you want to learn more about our mediation service, then schedule an appointment to talk about mediation. The mediation service could help you resolve your case without spending as much money on lawyers and legal fees. Our rate for mediations begins at $300 per side for a half-day mediation. And I think it's important for me to note here that if you hire our firm to assist you with mediations, we're not representing you, and we don't represent the other party. We're a neutral party, and we work with the two of you to help you reach an agreement that works best for you. We also provide a service that we call limited scope representation. If you choose to do limited scope representation, then we will provide certain services for you for a fee. Think of it like an a la carte menu where you pick and choose what you want us to do for you. We will provide the forms, documents, and phone consultations, but you will represent yourself in court. If you want my firm to appear in court on your behalf, then we're happy to do that. Here's how the pricing works for that service. If you have an amicable divorce, or what many people call an uncontested divorce, then we charge $3,000. Now, please note that when I say the divorce is uncontested, I mean you and the other party agree on all the terms. If you do not agree on all the terms and a judge is needed to decide things for you, then you have a contested divorce or a contested case. For contested cases, you can expect to pay from $5,000 to $10,000 for my firm's services. If your divorce involves a business or professional practice of some type, then you can expect your case to cost more than $10,000 to resolve. Now, sometimes they cost less, but you should go into it expecting that it would cost more than $10,000 to resolve if you've got those kinds of complex issues to deal with. Now, I told you at the beginning of the webinar that I would give you a helpful free gift, and here it is. I'm offering my ebook, The Checklist, to you for no charge. This short ebook provides useful things that you should consider doing once you've decided to leave your relationship. It's got 50 tips, and they're very useful. You can put them in place whether you've got an attorney or you're representing yourself. And some of the things that you put in place will make things much easier for you when you hire an attorney, or they'll make things much easier for you if you're representing yourself. These tips will give you a better chance of achieving the result you want to achieve in your case. So to get this book, this ebook, you want to text breakup tips, that's one word, breakup tips, to 555-888. You want to text breakup tips to 555-888, and we will send that ebook to you through your phone. Or you can send an email to me and request the book. My email address is damon@damonmoore.com. That's DAMON DamonMoore.com. Normally at this point I would take questions, but I'm out of the office doing something fabulous that I can't wait to tell you about soon. So I'm not going to be set up to take questions about or during this particular webinar. But you're welcome to schedule an appointment. You're welcome to ask questions that you have during that appointment. You can also send an email to me. Again, my email address is damon@damonmoore.com. I hope you've received some value from this webinar, and I look forward to working with you as you continue through this chapter of your life. Please feel free to reach out to me. Bye for now. Where an asset is purchased during the marriage with monies that are traceable to the spouse's separate estate, the asset may be appropriately characterized as separate property. So, for example, if your mother gave you $100,000 before you were married and you bought a house for $100,000 after you were married, then you might be able to argue that the house should be deemed your separate property because it was purchased with money that is traceable to your separate estate. Another concept is called reimbursement, and here's how that works. In Texas, we know that community property law is focused on distributing the community assets in a way that is just and right. But the law tries to account for circumstances in which one spouse may be entitled to reimbursement even if the reimbursement results in what appears on the surface to be an unfair distribution of the community property. Now here's an example of that. The wife owns a family home prior to the date of the marriage. And during the marriage, both spouses use their community assets or their shared income to make, let's say, $20,000 in renovations. Since the wife owned the house before the couple was married, the home would be considered her separate property. And this means that it would be hers to keep. The home would be hers to keep after the couple's divorce. But under those circumstances, the wife would be getting to keep the house and the entire $20,000 worth of renovations. Well, the Texas Family Code recognizes that that's unfair, and so it addresses the issue through this concept of reimbursement. So under Section 3.402 of the Texas Family Code, the court may choose to reimburse a spouse under 9 circumstances. If it's a claim for reimbursement, that includes payment by one marital estate for the unsecured liabilities of another marital estate, inadequate compensation for time, toil, talent, and effort of a spouse by a business entity that's under the control and direction of that spouse, the reduction of the principal amount of debt secured by a lien on property owned before the marriage, at least to the extent that the debt existed at the time of the marriage, the reduction of the principal amount of debt secured by a lien on property received by a spouse as a gift or devise or descent during the marriage, at least to the extent that the debt existed at the time the property was received. What's another one? The reduction of principal, or the reduction of the principal amount that is part of a debt, including a home equity loan.